Hi, me Norfata Adila, and my other friend is Azrina Aisha and Sita Hamila. We are from TG2 and Group A. So today we are going to present International Business Law for group presentation. The main issue is that the shipper declared the cargo as the metal parts, but it was actually a flammable solvent. Because as this wrong declaration, a fire has tortured and destroyed the whole cargo. So the question is that the iconic line label for the losses? The law that has been applied in this case is the Hague Vis rules, which are part of the Malaysian law under the Carriage of Goods by Sea Act 1950. Under Article 3, Section 2, a carrier must properly and carefully handle and take care of the cargo during the journey. However, the law also protects the carrier under the under Article 5, subsection 2. The carrier is not liable for loss caused by danger that cannot be discovered, even doing the reasonable check. This is very important when the cargo is dangerous but misdeclared by the shipper itself. In this case of the Manchester coastal, the court said that the carrier is not responsible for the hidden danger that they couldn't find. In Canadian Star Line versus the Mizzen, the court decided that when a shipper wrongly declared dangerous good, the carrier not be liable if the normal inspection were done. In this case, the Oceanic Line did its duty. The carrier checked the ship, followed safety rules, and handled the cargo properly. The fire happened because of the hidden danger inside the cargo, not because the carrier mistake. If the shipper had declared the cargo correctly, Oceanic Line could have taken extra safety step because the wrong declaration, the fire was beyond the carrier control. In conclusion, Oceanic Line is not liable for the cargo losses. The losses was caused by the misdeclared dangerous goods, and the carrier had already taken reasonable care. The law protect the carrier in this situation. Right now, I'm going to present a scenario from the question one, but in a different cases. For the cases of number two, I will discuss whether the isonic line is liable for misdelivery and conversion of the wheat when the cargo was delivered to the wrong party because of their worker's mistake. The legal issue here is whether the isonic line can avert responsibility by using the exclusion clauses even though the cargo was delivered to the wrong person. First, let's look at the rules of the law. A negotiation bill of lading is an important document. It shows who's on the goods. The carrier must deliver the goods only to the person who holds the original bill of lading. If the carrier delivered the goods to someone else, even by mistake, it is still considered wrong. This is a breach of contract and also amounts to the conversion. In the cases of Robinson versus the Crown Dry, the court held that delivery without the bill of lading is wrong, even if the carrier acted heinously. This shows that an innocent mistake is not an excuse. In Norway America Line versus the Hague Line, the court decided that carriers are responsible for the mistake made by their employees. This is because workers act on behalf of the carrier, so the carrier is liable. Under the car Under the Carriage of Goods by Sea Act 1950, the carrier has a strict duty to deliver the good correctly. Exclusion clauses can protect the carrier even there is misdelivery that breaks the term of the bill of lading. Now, let's apply this to the case. Here, Tropicana Mills presented the original bill of lading, but the wheat was delivered to another party due to the worker's mistake. This was clearly breaks the carrier duty. Even though the mistake was not intentional, Oceanic Line is still responsible. The carrier cannot rely on exclusion clause because delivering goods to the bill holder is a basic duty that cannot be avoided. Because of this mistake, Tropicana Mills has the right to claim damage. In conclusion, Oceanic Line is liable for the misdelivery and the conversion of the wheat. The carrier failed to deliver the good to the rightful owner and is responsible for its employee actions.
Moving on to the question number 2. First, let me explain the issues. The first issue is whether under a CIF contract, a buyer is required to pay for the goods based on the documents even if the goods were lost at sea. The second issue is whether under an FOB contract, a buyer's failure to nominate an effective vessel within the agreed time amounts to repudiatory breach, allowing the seller to terminate the contract. Moving on to the rule of law. Under a CIF contract, the seller's main obligation is to ship the goods and tender confirming documents to the buyer. These documents include a clean on-board bill of lading, an insurance policy, and a commercial invoice. Once these documents are presented in compliance with the contract, the buyer must pay for them immediately. Importantly, risk passes to the buyer once the documents are tendered, not when the goods physically arrive. Therefore, even if the goods are lost at sea, the buyer must still pay, as long as there is no fraud and the documents are in order. In contrast, under an FOB contract, the buyer must nominate a suitable vessel within the agreed time so that the seller can load the goods. In commercial contracts, time stipulations are usually treated as conditions. If these time requirements are breached, the innocent party has the right to terminate the contract. Next, I will apply the law to the facts. In the CIF case, Orchard Exports shipped the rice, but unfortunately, the vessel later sank. Despite this loss, Orchard Exports provided Mill with a full and compliant set of documents, including clean bills of lading and an invoice and valid insurance policies. Since the documents were conforming and the risk has already passed to Mill was legally obligated to pay upon presentation of the documents, even though the rights no longer existed at the time of payment. Mill's proper remedy will be to claim compensation from the insurer, not to refuse payment to the seller. In the FOB case, Global Foods was required to nominate an effective vessels and provide notice of readiness by 1 June. However, they failed to do so until 15 June, which prevented Orchard Exports from shipping the goods within the agreed time frame. Given the commercial importance of the certainty in shipment dates, this failure amounted to a breach of a condition, entitling Orchard Exports to treat the contract as terminated. Finally, the conclusion. In conclusion, under the CIF contract, Mill must still pay Orchard Exports despite the loss of goods at sea, because payment is based on documents. Under the FOB contract, Global Foods' failure to nominate a vessel on time constitutes a repudiatory breach, allowing Orchard Exports to lawfully terminate the contract.
Next issue arises in this case is the free of board, the late nomination of this issue, whether the Global Food as the buyer breached the FOB contract by failing to nominate on effective vessel by 1st June, and whether this failure allows Orca Export as a seller to terminate this contract. In the FOB contract, the buyer has several important duties. The most important is to nominate a suitable vessel within the agreed time. The buyer must tell the sellers which ships to use and pay all costs and risks after the goods are on board, because time considered as important elements in the FOB contract. So, shipment date is usually treated as condition, not minor terms. This occurs when the buyer failed to nominate the vessel on time. As the seller, Orca was prevented from performing part of the contract, and the purpose of the FOB contract was frustrated. The late nomination should not be the technical mistake, because it is the root of FOB, and it could affect the entire shipment. This case led to the Bunga and Corporation versus the Tradex Export in 1981, which highlight the buyer duty to nominate an effective vessel. This established FOB contract where the buyer has duty to nominate a vessel that can load the goods within the agreed shipment period. This duty is a condition of the contract, so any failure to nominate in time can entitle the sellers to claim breach. Conclusion: Global Foods failure to nominate the vessel by the agreed time. Orca Export as the seller was entitled to terminate the contract because Global Foods' argument that the terms was not a condition is unlikely to be succeed.